Tonight, FBI Director Kash Patel grilled over the Jeffrey Epstein files. Patel now saying that he has never talked to President Trump about the files. Here's Pierre Thomas.
FBI Director Kash Patel back on the Hill, facing House Democrats laser focused on his handling of the Epstein files.
Did you ever tell Donald Trump his name is in the files?
I have never spoken to President Trump about the Epstein files.
Democrats trying to tie President Trump to the files.
Did you tell the Attorney General that Donald Trump's name is in the Epstein files?
The question has been asked and answered.
You've not answered it, and we will take your evasiveness as a consciousness of guilt.
And Thomas Massie of Kentucky, a top House Republican, challenging Patel on his claim that there's no credible information Epstein trafficked women to anyone other than himself. His claim coming after several alleged victims of Epstein spoke out, some threatening to release a list of people they say Epstein trafficked women to.
Yo guys, Adam is here. What just happened? A federal judge stripping away your only legal protection, putting you under oath, and telling you that your only two options are the truth or prison. That is the exact position Kash Patel found himself in. And what he said in that room, locked permanently into the official record of one of the most consequential criminal cases in American political history.
How often do you speak to Stephen Miller?
Frequently on our Homeland Security task forces.
You frequently talk with Stephen Miller about subjects other than Homeland Security task force issues, correct?
I frequently talk to Mr. Miller about Homeland Security task forces.
Has Stephen Miller ever given you his opinions on how to run your agency?
Mr. Miller's interagency operations are invaluable to the FBI. That's what we talk about.
So you frequently discuss your job and your responsibilities with Stephen Miller and Pam Bondi, I imagine, as well.
Absolutely. She's the Attorney General.
Understood. Okay. Donald Trump promised to make us all safer. You have pushed out senior FBI agents with decades of knowledge and experience. In fact, this is the first time in FBI history that neither the director nor the deputy director have any experience with the FBI.
Has Donald Trump cornered in a way that no tweet, no threat, and no loyalty test can undo. This story has layers, and every single layer makes Trump's situation worse. Stay with me, because by the time we get to the end of this, you are going to fully understand why prosecutors, legal experts, and investigators are treating what happened with Patel as potentially the single most damaging inside account that exists anywhere in the entire classified documents case.
The gentleman from New York is recognized. Mr. Goldman.
Mr. Patel, does Donald Trump appear anywhere in the Epstein files?
I'm sorry, could you say that again?
It's not a complicated question. Does Donald Trump appear anywhere in the Epstein files?
I didn't say it was a complicated question. I just didn't hear you, so my apologies. We have released where President Trump's name's in the Epstein files and everybody else, and all credible information that we are legally allowed to release has been released.
All right, so let's go through that. You're referring to court orders that prohibit you from releasing grand jury testimony under Rule 6E. Is that what you're referring to when you say as the law allows?
That's a piece of it.
Really? What other evidence do those three court orders you cited prohibit from being released?
Information that was collected pursuant to those search warrants that were limited in fashion.
Let's go. Here is the foundation of everything. Judge Beryl Howell granted Kash Patel limited immunity so that special counsel Jack Smith could legally compel him to testify about Trump's handling of classified documents at Mar-a-Lago. That single decision by the judge set off a chain of events that ultimately put Trump in the most legally precarious position of his life. Before the immunity grant, Patel did exactly what any lawyer would tell a client in his position to do. He invoked the Fifth Amendment. Over and over again. Question after question. Fifth. And that is entirely understandable, because Patel's honest answers to those questions had the potential to expose him to serious criminal liability. The Fifth Amendment exists precisely for this situation. It is a constitutional shield against being forced to incriminate yourself. But here is where Judge Howell's immunity grant changed everything. The moment that immunity was granted, Patel's Fifth Amendment shield became legally irrelevant. The immunity provided him protection. His testimony could not be directly used against him in a criminal prosecution, And because that protection existed, he no longer had a legal basis to stay silent. The shield was gone. He was now sitting in that room with exactly two choices in front of him: answer every question honestly or face contempt and perjury charges. There was no third door, no escape hatch, no clever legal maneuver that gets him out of it. That is what legal experts mean when they describe a witness being legally trapped. Not physically, not by handcuffs or locked doors, by the absolute mathematical certainty that silence leads to contempt and lies lead to perjury, leaving honesty as the only option that does not end with criminal consequences. Kash Patel, the man who was present for the private conversations, who heard what Trump said, who knows what Trump instructed people to do with those classified documents, was legally required to describe all of it under oath, with the full weight of perjury consequences ensuring the most truthful account he could possibly give. And that testimony is now locked into the official record of the classified documents case. Permanently, irrevocably. Whatever Patel said in that room, whatever he described about what he saw, what he heard, what Trump told him to do, it is sitting in the official record right now, produced under the most legally coercive conditions that exist in the American justice system. This is why the word cornered is the most accurate description available. Trump is not cornered by a political opponent. He is not cornered by a biased investigation or a partisan process. He is cornered by the sworn, immunity-compelled testimony of one of his most loyal allies, a man who had every personal motivation to protect Trump, but who was legally stripped of the ability to do so the moment that immunity was granted. Now let's talk about what happened next, because this is where the story takes a turn that raises deeply alarming questions about obstruction and institutional abuse. Kash Patel provided his compelled testimony about the classified documents investigation. He described under oath and under perjury threat what he witnessed, what was said, what was done. That testimony went into the official record, and then Patel became FBI director. And one of the first things he did upon assuming that role was order the removal of at least 10 FBI employees who had been directly involved in the classified documents investigation, the exact same investigation his testimony was about. CNN and other major outlets documented this. At least 10 agents, gone, purged from their positions. And not just any 10 agents, specifically the ones connected to the classified documents probe. The same probe Patel was compelled to testify about. The same probe whose contents and findings represent the most consequential institutional knowledge about Trump's handling of the documents at Mar-a-Lago. Stop and sit with the specific alignment of those two facts for a moment. Patel testifies under immunity about the classified documents case. Patel then gains institutional authority as FBI director. Patel then immediately uses that authority to remove the agents who know the most about the classified documents case. The agents whose institutional knowledge of that specific investigation is most directly relevant to any future use of the immunity testimony in accountability proceedings. The question that combination raises, the question that legal experts and investigators are asking directly, is whether that purge was designed to eliminate the specific people most capable of interpreting, contextualizing, and weaponizing Patel's own compelled testimony against the former president. Whether Patel used the most powerful law enforcement position in the country to protect himself and Trump from the consequences of the very testimony he was forced to give. That is the obstruction dimension of this story, and it is serious, because there is a profound difference between an FBI director making personnel decisions for legitimate performance-related reasons and an FBI director removing the specific agents connected to the specific investigation he personally testified about. The former is ordinary management. The latter is the most alarming available alignment between personal accountability interests and institutional power. But wait. Because the accountability picture does not stop there. It compounds further with a third layer entirely separate from the testimony and the agent purge. The Campaign Legal Center filed a formal ethics complaint asking the Department of Justice Inspector General to investigate Kash Patel for allegedly taking at least 10 personal trips on government aircraft without reimbursement, 10 trips on government planes for personal use, without paying back the public for it. That is the allegation, and the filing of that complaint triggered a specific process, an Inspector General investigation that will generate its own documentary record, its own examination of Patel's travel patterns, his communications, his decision-making during the relevant periods. Now here is why that ethics layer matters in the context of everything else. A witness facing one dimension of accountability pressure has limited incentive to fully cooperate. They can manage a single exposure point through careful, strategic engagement. A witness facing 3 completely independent accountability dimensions, prior compelled testimony that is already locked in the record, obstruction accusations arising from the agent purge, and now personal ethics violations under active IG investigation, has a fundamentally different calculation to make. 3 separate tracks of exposure, 3 separate sets of potential consequences. 3 independent reasons why maximum cooperation and honest disclosure become the only rational path forward for a person who wants to protect themselves. That is the leverage picture that exists around Kash Patel right now. And it did not assemble itself by accident. It assembled itself because of the specific choices Patel made, invoking the 5th, losing that shield, testifying, then purging agents, then allegedly misusing government resources. Every piece of it connects to the others. Every piece of it compounds the pressure on him. And on top of all of this, there is Congress. Patel has been hammered in congressional hearings over his handling of the Epstein files, over specific accusations that he is actively shielding Trump and powerful allies from exposure rather than pursuing justice. The question of whether the nation's top law enforcement officer is running interference for the president instead of enforcing the law against him is not a fringe concern. It has been raised directly on the record by members of Congress. Let's now get precise about why the locked-in character of that original immunity testimony is more consequential than most people realize. There is a meaningful difference, a legally and credibility significant difference, between a witness who chooses to cooperate and a witness who is legally compelled to testify under immunity. A cooperating witness has agency. They can shape their account. They can present the version of events most strategically favorable to their interests. They can emphasize certain things and minimize others. Their account carries the credibility discount of a person who chose what to reveal and how to reveal it. Patel's immunity testimony carries none of that discount. He did not choose to sit in that room. He did not choose to answer those questions. He was legally required to be there, legally required to answer, and legally required to tell the truth or face criminal consequences. The account that came out of that process is, by definition, the most honest account Patel was capable of giving under the most coercive legal conditions that exist. And it is now permanently in the official record, not as a voluntary statement that can be walked back or reframed or updated later, but as a locked-in sworn account produced under conditions specifically designed to extract the truth. Whatever Patel told Jack Smith about what Trump said, about what Trump instructed, about what happened privately with those classified documents at Mar-a-Lago, it is sitting in that record right now. And prosecutors know exactly what it says, even if the public does not. Trump is cornered not by what might happen, but by what has already happened. The most consequential inside testimony about his classified documents case has already been given. The most honest available account from the most credentialed available inside witness has already been locked into the official record. The man who provided it then took actions as FBI director that created serious obstruction questions, and that same man is now the subject of an ethics investigation, adding a third layer of accountability pressure on top of everything else. So where does this go from here? There are several specific developments that will determine how this story reaches its next inflection point. First, the Inspector General investigation. Whether the Campaign Legal Center's aircraft complaint actually triggers a formal IG investigation will determine whether that third layer of accountability pressure becomes a documented, official process with its own evidentiary record or remains an allegation. If the IG investigates and finds documented violations, Patel's accountability exposure compounds further, and his incentive to cooperate fully in any future proceedings increases accordingly. Second, the Congressional subpoena. The House Oversight Committee has issued document requests and a deposition request to Patel. Whether that process produces a second round of compelled oath-bound testimony, this time in a congressional setting with the prior immunity account available as a baseline for comparison, will determine whether the legislative branch adds its own layer of documented sworn testimony to the record. A congressional deposition that can be compared line by line against the prior immunity account creates enormous pressure on any witness whose stories have diverged in any way. Third, the unsealing question. The immunity testimony exists in the official record, but much of its contents remain sealed from public view. Whether any transparency application or court order eventually brings those specific contents into the public record will determine whether the locked-in account remains a documented but non-public weapon or becomes the most visible inside account of the classified documents situation available to the American people. And fourth, the overall accountability trajectory. Whether the three-dimensional pressure picture, prior testimony, obstruction accusations, and ethics exposure creates the conditions under which Patel determines that maximum cooperation is the only viable path for self-preservation. Because the math on that question is not complicated. A witness with one exposure point can gamble on managing it. A witness with 3 independent exposure points, each capable of escalating independently, has a much stronger incentive to get in front of the problem with full cooperation rather than to fight it on 3 separate fronts simultaneously. Here is the bottom line that I want you to carry away from everything covered today. Judge Beryl Howell granted Kash Patel limited immunity. Jack Smith used that immunity to strip away Patel's Fifth Amendment shield and legally compel his testimony about Trump's classified documents. Patel invoked the Fifth repeatedly, lost that protection, and was left with no legally available option other than honest testimony under perjury threat. That testimony is now permanently locked into the official record of the classified documents case. Then CNN documented that immediately upon becoming FBI director, Patel ordered the removal of at least 10 agents specifically connected to the classified documents investigation, the same investigation his testimony was about. Then the Campaign Legal Center filed a formal ethics complaint requesting an inspector general investigation into at least 10 personal government aircraft trips allegedly taken without reimbursement. And Congress has hammered Patel directly over the Epstein files and accusations that he is running interference for Trump and his allies rather than doing his job. 3 independent layers of accountability exposure, one person sitting at the center of all of them, and the most honest inside account of what Trump said and did with those classified documents already sitting locked in the official record, produced under the most legally coercive conditions possible, waiting for the specific moment when its most consequential use becomes available. Trump is cornered, not by a political attack, not by media speculation, by the sworn testimony of his own most loyal inside man, compelled under immunity, locked into the record, and now surrounded by additional accountability pressure that makes the pressure to cooperate fully greater than ever. The IG investigation is developing. The Congressional subpoena is active. And every single development as it unfolds will be covered in full. The question is not whether the walls are closing. They clearly are. The question is how fast.